The Trump trial jury instructions have been released. We now have the drafts. These are not the final official versions, but these have been jointly submitted from both sides, and so they're very, very close. Judge Mercan is going to issue the final red lines on them, and then they're going to go off to the jurors. But this came in from both sides, from the government and from the defense, joint motions for various components of the Bragg prosecution. We know 34 counts, falsifying business records is the main charge, and so we'll look at those instructions first. But there were also the predicate offenses, the object offenses. The idea being that this got escalated from a misdemeanor into a felony because Trump not only was falsifying business records, allegedly, which would have been a misdemeanor, but he was falsifying those business records in order to commit some other offense, or to intend at least to commit some other offense. What other offense? We still don't know, but we're going to explore two jury instructions, one for the FECA violations, one for the New York election law violations. We still don't know if tax law is going to come into the jury instructions, but we have a placeholder for that when that one is released. Now, the problem here is that the judge has now come out and said any crime that is a predicate crime is sufficient. In other words, the jurors don't have to agree unanimously on one of these other object offenses. Of course, we think that is dead wrong. Greta Van Susteren also agrees, and you know who else does? The Supreme Court. We have a case called Richardson versus United States, which shows us that you got to agree on the elements. That's kind of how the law works. We don't want it to be a pick a crime, any crime situation. Pick a card, any card, whatever you want, you're a winner. We need to have clear elements so the defense has notice about what those elements are. So we have some specificity about the crime. It's a due process problem that Judge Mercan apparently doesn't care about at all. So we'll go through the instructions. We'll also ask ourselves about accomplice liability, accessory liability, and then get reaction from inside Jen Psaki, Alina, Habba, and Doug Burgum to round out this segment. So stick around for that reaction. But first and foremost, Judge Mercan continues to try to rig this thing, saying the jurors can basically do whatever they want, just pick any crime that is sufficient, as long as it makes them feel good inside and they heard something that keys them off on that, good enough. And this makes it more difficult, I think, for Trump to get a hung jury, because they can all just pick whatever they want. They all just have a menu. I'll take that one. I'll take that one. You want that one? I would never have that. That sounds disgusting. But if that works for you, you can order that. So how do you have a hung jury when everybody can pick whatever they want? So here's the judge, apparently, according to Josh Gerstein, reporting for Politico, says, to convict Trump of felonies, the jury does not need to unanimously agree on what the predicate crime is. Wild. Whatever they want. Did he intended to do something bad? Well, what did he intend to do bad? Whatever you want. To find Trump guilty of felony level falsification, jury, of course, must find unanimously that there were falsified business records, but the judge ruled that not all jurors have to agree on what the separate crime was. Trump's defense argued that to issue a felony level conviction, all jurors should be required to agree on the predicate crime. That's what a unanimous jury is. You're unanimous on all of the elements. Prosecutors initially laid out 4 possible predicate crimes. One, the judge said no. The others are the tax crimes, the state crime, and the Fed election crimes. Now, the defense attorney, when we were in court, Emile Beauvais, he argued, he said, Your Honor, jurors should have to agree on a single predicate offense. But Matthew Colangelo, the Biden prosecutor who left the Biden DOJ to come resurrect this zombie case, said, the law doesn't require that. He says, Your Honor, no. The importance of the case is not a basis for deviating from the standard application of the law. The law says this. There's no reason to rewrite the law for this case. It doesn't say you have to be clear, just any crime. Mercan agreed with the prosecution and said he won't impose the requirement that the defense requested. In other words, if some jurors believe that Trump falsified business documents solely to cover up a tax crime, and other jurors believe no, he falsified business records to cover up an election crime, they can still convict him. That's how they're going to break the hung jury. The jury can still convict Trump on the felony level falsifying documents charge, despite disagreeing on the predicate crimes. Pick a crime, any crime, doesn't matter. You can just do whatever you want. This is not obviously justice at all, because the jury can choose their own adventure, whatever they heard. So Trump has to defend against a bunch of hypothetical crimes, which is basically impossible, because the jurors can just have a very loose, open standard, and they can agree on it. Now, this is what the judge has allowed. This is the judge's ruling. I think the judge is wrong, and I think the judge is going to get reversed on appeal, but they don't care about that. All they want right now is a felony conviction to stick. They need 34 felony convictions, or any, even if they split it, even if they say Trump is only responsible for the ones that he signed. So maybe they throw out the ones that were signed by Eric and Weisselberg. They still just need a conviction, and they'll be able to parlay that into their campaign. So the problem with that is it's wrong. Greta Van Van Susteren posted this one. Says, yeah, we looked this up. Says, here's the Supreme Court case on unanimity. She referenced Richardson versus United States. This came out from the Cornell Law School brief site. And here they give us some background on what this case was all about. That there was a trial that was looming. So some background on this actual case that Greta cited for us. Says there was this guy, his name was Richardson. There was a statute, you cannot engage in a continuing criminal enterprise. What does that mean? What was it? Did they have to prove in order for it to be continuing? Was it a series of violations? Was it one violation and you have to prove the one violation? Complexities about how the rules work, kind of a bad statute. Now, what happened was the judge instructed the jurors that they must unanimously agree that the defendant committed at least 3 federal narcotic offenses. So he said you committed 3 violations, but you did not have to agree on the particular offenses. So the government would throw up like 20 different options. That was an offense. That wasn't an offense. That was one too. Throw out a bunch of stuff to see what sticks. The jurors just have to pick 3. There's 20 options, just pick 3. The jury said, oh, we can do that, no problem. So they convicted him easily, obviously. But this got reversed. Nope. The case must unanimously agree, a jury, that not only that the defendant committed a continuing series of violations, so the sequence, but also about which specific violation make up the continuing series. So you have to be specific about each sub-violation in order to get the continuity. Very similar to what we have here. In terms of, we have a series of checks. They're alleging a conspiracy. There is no conspiracy charge. And they're saying that Trump, they don't have to prove what the object offense was for the business records. They say a jury in a federal criminal case, this was the Fed level, not the state level, cannot convict unless it unanimously finds that the government has proved each element of the offense. However, it doesn't need to do so when there are several possible means. So now we're talking about the means to do the offense and the elements of the offense itself. But they tell us that if you can just aggregate this stuff, it's a problem. If each violation is a separate element and we want juror unanimity, that protects the law. If we don't do it, we will cover up wide disagreement amongst the jurors. If we allow them to choose their own adventure, this is the policy reason why we don't do this. We will cover up wide disagreement. We'll just paper over it. That's exactly why Judge Merchan is allowing this, because it gives them their own options. And the government may also seek to prove that there were numerous underlying violations. And the court has also indicated that the Constitution itself limits the state's power to define crimes in ways that would allow juries to convict while disagreeing about the means when there is unfairness in the process. So we want unanimity. We don't want people to have their own adventures, because then everybody goes to prison for anything the jurors want. Everybody is going to hear something that they didn't like, but it's proving it beyond a reasonable doubt. Not everybody just gets to order off the criminal menu. So Judge Merchan is wrong about it. He doesn't care that he's wrong about it. He's perfectly okay being wrong about it. He's been put here for a reason. He has a mission, and which is to lead to a certain outcome, and he's creating the rules of the game to get us there. Now, he is going to be considering jury instructions, and so let's take a look at what these look like. These are the proposed jury instructions, and these have come in from both sides. This is what Judge Merchan is now considering prior to issuing the final instructions to the jurors. So the jurors will get something that looks just like this. It says, the first count, ladies and gentlemen, is falsifying business records in the first degree as it pertains to an invoice from Michael Cohen. Remember, it's invoice, ledger, and check. Felony, felony, felony times multiple months equals 34. Marked as a record of Trump's revocable trust. Now, under our law, these are the instructions, a person is guilty of falsifying business records in the first degree when he has the intent to defraud. That includes an intent to commit another crime or to aid or conceal the commission thereof. That's the aggravator. That person makes or causes a false entry in the business records of an enterprise. So that's the object offense. This is pointing to something else. Commit another crime. The question is what? They define this for us. Enterprise means any entity, one or more persons, commercial, business, industrial. So someone will say, oh, I heard Trump Organization, so that sounds right. A business records, including computer data program, reflecting its condition or activity. So they'll say business record. Okay, that's a ledger. We heard a witness with a ledger talk about bookkeeping, right? Thinking as a juror might. Intent means conscious objective or purpose. Okay, so now we get into some complexities. Thus, a person acts with intent to defraud with his or her conscious objective is the purpose to defraud. Now, the defense wants this sentence in. Thus, a person acts with intent to defraud when his or her conscious objective or purpose is to lead another into error or to disadvantage. Did any of this post NDA stuff lead someone into error or to disadvantage Stormy? No, she made money. So the defense wants to narrow it down so the jurors have questions over that sentence. The government does not want that sentence in. A person causes a false entry when, even if he does not prepare the business record, the creation of the business record is reasonably foreseeable consequence of his conduct. So did Trump do something to cause this business record to be entered and entered falsely? Intent does not require premeditation, they say. In other words, intent does not require advanced planning, nor is it necessary. The intent is in the brain for a certain period of time. The intent can be formed, need only exist at the very moment they do it. How do you determine intent? They say, jurors, you must decide if the required intent can be inferred beyond a reasonable doubt. You may consider their conduct. What did they say? What result followed their conduct? What's the probable consequence of that conduct? And therefore, in this case, from the facts you've decided, do you think that this person had the intent to commit the crime? Judge says, as I previously explained, a person acts with intent to defraud, defining that phrase, when his or her conscious objective or purpose is to defraud. In order to prove that, the government need not prove that the defendant Trump acted with intent to defraud any particular person. So it can be defraud anything, just a general intent, wow, to defraud any person or entity, including the government or the voting public, suffices. So I don't know if the defense is objecting to that, right? I would presume that that is probably a government sentence that's highlighted yellow, but I don't know. Intent to defraud is also not constricted to an intent to deprive another of property or money. In fact, intent to defraud can be extended beyond economic concerns. So all the liberal jurors are like, bingo, bingo, bingo. Now, for the count of falsifying business records, the intent to defraud must include intent to commit another crime. Saying under our law, although the people must prove an intent to commit another crime, they don't need to prove the other crime was in fact committed. In addition, there's no requirement that the defendant intend to conceal or aid the commission of his own crime. Instead, a person can commit this crime by having intent to cover up a crime committed by someone else. So that's a sentence for Michael Cohen. Michael Cohen committed a crime, so Trump maybe paid him back and falsified the business record to cover him up. So in order for you to find Trump guilty of this crime, the people are required to prove each of the two elements beyond a reasonable doubt. First, that on or about February 14th, Trump personally or by acting in concert with another caused a false entry in business records of an enterprise, which was an invoice from Cohen to Trump. And then lastly, second, they got to hit both of these. So these are the elements. And then second, that the defendant did so with the intent to defraud that included an intent to commit another crime or to aid or conceal the commission thereof. Now that is verbatim from the statute. So what Trump's defense wants is to add in this second sentence. So they want to tighten that up because, right, Trump did so with intent to defraud that included an intent to commit another crime. Well, what other crime? Whatever you want, jurors, just whatever you want. Leave it open-ended. Take that blue sentence off and you can do whatever you want. Thus, for this second element, the defense wants this in there. We'll see what the judge does with it. Thus, for the second element, the people must establish beyond a reasonable doubt two separate intents. One would be intent to defraud and the intent, typo there, to aid or conceal the commission of another crime, which I will define for you shortly. So they want the other crime, essentially, to be specified. What was the intent and the intent for the other crime? This should be unanimous based on what that other crime is. So it could be one of three options, but I'll define it for you shortly. So the judge will probably nix that sentence and leave this much more open-ended. You don't want a bunch of additional rules. Just open up that hula hoop, expand it so that the jurors can pick whatever they want. This is a big wide open option. You can pick, this crime or this crime or this crime or this crime or this crime. The defense is right here. You can only dance within this location. So, all right, that is the main charge. And they're still going to decide, I think, on these details. I can't tell what these are, so what the defense is objecting to, but I think we've got an idea of what that would be. So that's the main charge. Now, we also have the object offense. So again, Trump created a false business record with intent to commit another crime, but not actually commit the crime. Doesn't have to actually be convicted for it. Just intent. Doesn't have to take steps in furtherance of it. So federal election crime. Under the Federal Election Campaign Act, the jurors are told this: it is unlawful for an individual, defense wants the word willfully in there, to make a contribution to any candidate with respect to any election for federal office. In 2016, the limit was $2,700. They again want an intentional type of word. It's also unlawful under the FECA for any corporation to willfully make a contribution of any amount for a candidate. In 2015 and 16, the defense wants this added. They want to say there was no limit on a candidate's ability to contribute personally personal funds to his or her campaign. So in other words, Trump could have used his own money, as he did, and so that would allow him to do this. So the judge will probably keep that out because this takes the meat out of the rest of this, right? This makes it sound like Trump did something illegal. They also say the terms contribution and expenditure include anything of value, including any purchase. Defense wants the phrase, the purpose of influencing any election requires proof that the activity clearly, unambiguously related to the campaign. Judge will nix that for sure. They say under federal law, a third party's payment of a candidate's expenses is deemed to be a contribution. So Michael Cohen paid, that was his contribution. Now, the defense wants there are a number of issues arising from a candidate's personal situation that may become campaign issues, but expenses arising from those contributions are not necessarily campaign expenses. Okay, so Trump can pay for things that, yes, they'll help his campaign, but they're also regular things. He doesn't want his wife to know about the NDA, or he doesn't want his wife to know about the affair, right? Even if it's alleged, whether it's real or not. The brand, the Trump brand, doesn't benefit from Trump being an adulterer. So yes, it's going to help the campaign, but it's also necessary for other components of his professional life. Now, the political impact of legal issues on a campaign will not by itself, Trump wants this in here, justify the treatment of any legal expense as a campaign expense. Legal expenses are not campaign related merely because of the underlying legal activities have some impact on the campaign. If the payment would have been made even in the absence of a candidacy, the payment should not be treated as a contribution. Would Trump have signed this anyways if he were not running? They give us the FECE definition of contribution and expenditure does not include any costs for news magazines. So they're trying to say Trump, that was illegal. And Trump's team says, no, this is called press exemption. Legitimate press function is a broad concept. For example, the term legitimate press function includes solicitation letters and seeking new subscribers to a publication. So maybe we are allowed to do that and add that into the instructions so the jurors can wrestle with that. I'm sure basically every one of these blue sections that is proposed by the defense will not be included. So that is FECA. This is the New York predicate. The people also allege that Trump intended to commit or violate New York law. Section 17152 of New York election law says that if two people conspire to promote someone by unlawful means, that's illegal. Under our law, a person is guilty of conspiracy, which Trump was never charged with intent that conduct be performed that would promote or prevent the election of a public person to public office. Now, knowledge of a conspiracy does not make the defendant a co-conspirator. The defendant must intend that conduct be performed to promote or prevent the election. Intent means conscious objective or purpose. Thus, a person acts with intent when it's their conscious objective. Now, thus a person acts with intent that conduct constituting a crime be performed when the person acts willfully with a conscious objective. Evidence that Trump was present when others agreed to engage in the performance of a crime does not by itself show that Trump personally agreed to engage in the conspiracy. The defense wants this added. Proof of a separate or independent conspiracy is not sufficient in determining whether or not any single conspiracy has been shown by the evidence in the case. Jurors, you must decide whether common goals or objectives existed which served as the focal point for the efforts. You may consider the length of time, the conspiracy, mutual dependence, and other things. Now, although you must conclude unanimously that Trump conspired to promote or prevent the election, you need not be unanimous as to what those unlawful means were. So they can just pick whatever they want. In determining whether Trump conspired to promote or prevent the election of any person to public office by unlawful means, you may consider the following unlawful means. It's incredibly circular. So violations of the FECA, the falsification of other business records, or the violation of tax laws. So this is insane, but these other business records, I'm guessing not the business records in this case. So what are they talking about? It must be the AMI records. It must be the Drew B. McDougal and AMI records. So Trump falsified those records. Those records were falsified in order to promote or further a conspiracy. Under New York law, a conspiracy violates state law. That would be the predicate crime. We're like 7 layers deep now. It's like Inception. Before we get back to the original offense, which is the false business records escalated into a felony. Now, as I mentioned, the judge is telling the jurors, this requires proof that the goal of the conspiracy, this is what Trump's team wants, is to promote the election of a person by unlawful means. Now, the people allege that the unlawful means at issue involve the FECA, the falsification of other business records. But you must reach a unanimous decision whether the people have established unlawful means, and if so, which unlawful means were at issue. I will provide you with the verdict form so you can indicate your conclusions on these issues, and that's also going to be important, the verdict form. Now, in addition, under New York law, false business records in the second degree is when you create false entries. For the purposes of determining this, you may use unlawful means. You may consider whether the bank records associated with Michael Cohen's Michael Cohen's account formation paperwork. So Trump is not being charged with a crime for Michael Cohen creating fake LLCs, but Michael Cohen did create fake LLCs, Resolution Consultants and Essential Consultants. And so they're saying he did that in order to enable this. Also, the bank records associated with Michael Cohen's wire. So Michael Cohen's transactions are now going to be used as evidence that Trump was furthering a conspiracy in violation of New York law. The invoice from Investor Advisory Services and the 1099 forms that the Trump organization issued to Michael Cohen. So they can just literally pick whatever they want. These are not even in this case as charged offenses. Trump is only charged with the false business records, but now everything else Michael Cohen did can be evidence that Trump wanted that done in furtherance of a conspiracy. Trump is part of a conspiracy because Michael Cohen did all these things. Now, also under New York law, there it is. There's the tax one. It's unlawful to knowingly supply or submit false information for tax returns. Under federal law, it's unlawful for a person to willfully make any tax return that's fraudulent, that you don't believe is true. And under federal, state, and local laws, this conduct is unlawful even if it does not result in the underpayment of taxes. So this is about as broad as it gets, my friends. This is not good news for the defense at all, in my opinion. I think this gives them an option to basically do whatever they want. And even a holdout is going to have a hard time not following these rules. Like, these are the rules they have to follow. If this is a board game and you get the rules, you follow the rules. Of course, the rules are rigged in favor of predetermined outcome. But if these are the rules and they can just pick any of these things, it's not legally accurate at all, but this might be what the jurors are getting. So absolutely wild to see it in writing. Now, here is where the jurors can give us some credibility concerns. They say, you listen to a convicted perjurer, you listen to a porn star and a bunch of grifters who absolutely hate Trump and want him destroyed. So you get to determine the truthfulness and the accuracy of the testimony of each witness. The judge says, ladies and gentlemen, now you must decide whether a witness told the truth and was accurate, or whether they testified falsely or mistaken. You must also decide what importance to give the testimony you accept as truthful. If you find any witness has intentionally testified falsely, you may disregard that witness's entire testimony. So if Michael Cohen lied on the stand, you can disregard his entire testimony, which the jurors should do. Or you may disregard so much of it as you find untruthful and accept so much of it as you find truthful or accurate. So just pick what you choose. Now, there is no particular formula for evaluating truthfulness. You bring to this process all your experiences. What you use in life, you can use here. Here are some things to consider. Did the witness have an opportunity to see or hear the events? Could they recall those things? Did they sound plausible? Were they consistent or inconsistent? Did the manner in which they testified matter? Did you consider their background, their training, their education? Did they show a conscious bias? Yes. Did they show hostility or some other attitude? Did the witness show an unconscious bias? You may also have some questions about their motive. They have a motive to lie. If a witness did have a motive to lie, you may consider whether and to what extent the motive affected their truthfulness. If they did not have a motive to lie, you may also consider that as well. You may consider whether a witness hopes for or expects to receive a benefit for testifying. Both of them did. If so, you may consider how that impacts them. Do they have an interest in the outcome of the case? Now, you're not required to accept the testimony of anybody who does. You may also consider their prior criminal conduct, and you may consider their inconsistent statements, whether they testified to a fact that was omitted and discovered later. For those inconsistent statements, you can decide if that impacts their truthfulness. You may also decide whether they are consistent. Now, you have heard the defense wants this included. You have heard testimony that a judge found that blank testified falsely in an unrelated proceeding. That's Cohen. And that judge's determination is not binding on your determination of Cohen's credibility in this case. You may, however, consider that determination along with other evidence in this case in evaluating the truthfulness of Cohen's testimony before you. And the government does not want that in there because they don't want to call attention that Cohen lied in another hearing. They don't want that coming out at all. So government will object to that. Judge will probably keep that out. You've also heard about speaking to witnesses in preparation for this. You should know that talking to witnesses is perfectly normal. We're allowed to do it. And that is it for the credibility jury instructions. Now, we also have some connections, accomplice liability, accessory liability. So they're instructing the jurors briefly on this one, saying under our law, Michael Cohen is an accomplice because there is evidence that he participated in a crime. The defense wants that. The government wants participated in and convicted of 2 crimes based upon conduct involving the allegation allegations here. They say our law in New York is especially concerned about the testimony of an accomplice who implicates another in the commission of a crime, particularly when the accomplice has received some benefits in return for the testimony. And so therefore, our law says that a defendant may not be convicted of a crime based on the testimony of an accomplice unless there's some corroborating evidence. In other words, even if you find the testimony of Cohen to be believable, you may not convict Trump solely on the testimony unless it was corroborated by other evidence. So Cohen committed a crime. Now he's just going to rat on the other guy. So that is not reliable unless you also have some independent evidence to support that. The corroborating evidence need not by itself prove the crime or that he's guilty, but what the law requires is that there tends to be a connection between the two. In determining whether there is necessary corroboration, you may also consider the testimony of Michael Cohen, and you may also consider whether there is material, believable evidence apart from Cohen that harmonizes with the narrative as an accomplice. So can Trump be guilty by implication? The jurors will be assessing that as well. Now, accessorial liability, our law also recognizes that two or more individuals can jointly commit a crime, acting in concert. Our law defines the circumstances when this might be held appropriate. It says, when one person engages in conduct which constitutes an offense, another is criminally liable when they have same state of mind, he or she solicits the other person and then aids that other person in the commission of the crime. Saying in order for Trump to be held criminally liable for the conduct of another, in other words, Trump got Cohen to do it, that Trump solicited someone else, that he or she was in the state of mind to commit the offense, the defense wants willfully in there. If it's proven beyond a reasonable doubt that the defendant is criminally liable, then the participation in the crime does not matter. The people have the burden of proving the stuff beyond a reasonable doubt, and we got a bunch of footnotes here. So, all right, so those are the jury instructions. All of them are now up for the judge's review, and they're not good. They don't look good. They're about what we expected. Not only is the judge saying they can essentially pick any predicate offense, but tucked in that second predicate offense, that New York election law offense, they can pick any other documents that they say were falsified as furtherance of a conspiracy to satisfy that predicate offense. I think it's going to be very difficult to get an acquittal, obviously, but even a hung jury, there's going to be a lot of pressure on holdouts to find a category in there. And if they don't have to agree, they can just choose their own adventure. It's going to be rough. So Biden is planning victory party on this. I think they might be intimating they know what the outcome is. Biden has stayed silent on the Trump trial. The verdict is going to change that. The Bidens will speak at some point, whether it's a conviction or not. He plans to break his vow of silence and publicly address the criminal trials. 4 people familiar with the deliberations have told Politico, Biden intends to initially address the verdict in a White House setting. So using the power of the pulpit to get out there, the White House setting will enable him to reach a huge audience, and he's going to use the official seat of the government to do it, to show his statement isn't political. Okay, he's going to address his prosecution of his political opponents and say it's not political. If the jury convicts him, Biden's team will argue the result shows Trump is ill-suited for what, falsifying business records? The campaign social media team is considering leveraging the line of attack even further, saying convicted felon Donald Trump. His team is also preparing for a barrage of Republican and Trump attacks. If he's acquitted, if there's a hung jury, they're going to escalate this. They're pretty excited about doing so. So Inside Jen Psaki was out there. We'll just play a short bit of this so you can see what these people are talking about.
He was a liar, that he's in it for his own ends, that he's in it for ego because he's not a spurned lover, but a spurned lawyer by Donald Trump and the like. And what the prosecution is going to say, picking up on what Andrew said just a moment ago, and I totally agree with it, is that this is not just a case about Michael Cohen. It's a case about Michael Cohen plus. Cohen is just gravy. And it's things like the Hope Hicks testimony that Andrew referred to, but it's also handwritten notes that we've got and those checks that you just flashed on the screen a moment ago, which picks up on paragraph 33 in the complaint. These are checks that Donald Trump himself signed. And so that shows knowledge of the whole scheme. And I think at the end of the...
All right, so Trump signed some checks as he does many other checks. The question is the jury going to pick his checks that he signed? Are they going to pick certain crimes that they think satisfy their appetite? Or how will this whole thing come undone? We've got Doug Burgum, who has been on the short list for vice president, who is also out, talking about how America has already acquitted Trump.
Well, first of all, I'd like to call it the alleged business filing error case, because that's really what the core of it is. And I think it's failed to get any traction because I think Americans see right through it. Americans have already acquitted Donald Trump. I think they realize that when you've got 5 weeks and you can't even prove or even articulate what crime has been committed. So I had a chance a week ago Tuesday to be in the courthouse with the president and observe for a whole day, not just get the filter of what the media might be telling you. And what I observed there, what I watched, that was the day that Michael Cohen went from wrapping up the prosecution's leading set of yes and no questions to watching him get destroyed by the prosecution. And it may have been the day that he also then now as a serial perjured himself again on that day, getting caught up in all the lies that he's had. And then the next day, on the Wednesday, going back to North Dakota, watching the media coverage, and it was like, I think that they were at a different trial than I was at. And so it's
on that point, do you think most of the media are rooting for a conviction?
Well, I think that certain business models in media today are geared around their audiences, and those audiences are absolutely, and I think the Biden administration has got it, their whole campaign is hoping for that. I mean, that's their whole strategy, is to be able to put a label on the former president that they think might be helpful. But I said Americans aren't buying. It's actually backfired because President Trump, who's the master of earned media, I mean, getting free press and getting attention and having all eyes on him. I mean, he's masterfully used this to help expose the weakness in a broad set of the lawfare that's going against him.
I think he's right about that. It's that third act. It's Batman is going into the exploding building. His car's gone. His girl's gone. His airplane's gone. He's just got that one rappel thing. And he makes it to the top of the building and everybody gets saved. You go, oh my gosh, these are insurmountable odds. How is he able to do it? And it's because people are recognizing it's unjust. Okay. Just like the Joker comes in, wrecks Gotham City. Joe Biden has done the same thing. People are saying, oh, that's not working out so well. So it feels like we're dealing with corrupt monsters. Now, Alina Habba comes out and explains it like it is. She says, you know what? They have no facts. In this case, it's Alina Habba.
The instructions we've been going back and forth with are going to be finally tweaked. The concern with the instructions, which is frankly the most critical part, they have no facts. Let's be clear. I sat through this trial and, I would tell you if I was concerned on factual basis. But as I've said, and I'm not speaking now to posture for the president, but just generally as an attorney, as an American who understands the law and how to apply laws to facts, there are no facts that support this alleged crime. We're not even sure what the crime is. So it's a books and records issue. We have to make sure that the jury charges that Judge Merchan, who again, we have said is severely conflicted for reasons that I can't speak to because of the unconstitutional gag order. But this judge is the judge that determines the jury instructions. The jury instructions are the roadmap for non-attorneys and jurors to follow the law. It's going to be critical. And frankly, at this point, I have zero confidence in the fact that this person, who should not be sitting on the bench right now, will do the right thing and give jury instructions that are in an appropriate manner without any persuasion towards the prosecution. There's my biggest concern. It always has been. There was no...
Yeah, it's hard to win a case when the jury instructions are telling the jurors to convict you. You can pick this one or this one. If you don't like this one, we'll get you this one. Would you like to try this one? How about some more of those? They have all the possibilities in the world. There's going to be a tremendous amount of pressure on them to convict him. So we'll be here to see if we get a copy of the final jury instructions. There's been some headlines, some rumors that maybe Judge Merchan will not, in fact, release the jury instructions or the jury forms until after they're rendered. We'll, of course, keep our eye out on those. And so thanks for subscribing and sticking around. We've got a bunch of other stuff here, including this other video coming up right now that you're going to love. So stick around, check that video out, and we'll see you over there.